Welcome to the Tenant Law Podcast, where all types of New York City tenants can learn about the laws that affect their apartments. Rent-stabilized tenants, free market tenants, good cause tenants, luxury tenants, loft law tenants, co-op shareholders, subletters, roommates, co-livers. Let's all learn to live better. Welcome to the Tenant Law Podcast. I am Michelle Itkowitz, and today we are discussing, do you have to allow landlord into your apartment to do repairs, even if you do not want to? First, as always, let's set the stage with some context. When a tenant leases a residential apartment, the tenant is contracting for exclusive possession of the apartment. That's not just gobbledygook. Exclusive possession. That's what makes a lease a lease. Exclusive possession means you can exclude the whole world, including the landlord. In other words, once the tenant rents the apartment, the landlord cannot go back into the apartment whenever the landlord feels like it. The landlord can only go into the apartment, with the exception of emergencies, when the tenant lets the landlord in or when a court says the landlord can go in. Second, we've often discussed this on this show, the implied warranty of habitability. It's always present, the implied warranty of habitability. Whether your lease says so or not, or even if you don't have a lease, you are entitled by law to a habitable apartment. If you want a deeper dive on the warranty of habitability, please look through our back catalog of episodes. We've done so many episodes on the warranty of habitability and getting repairs. Today, we're talking about a particular aspect of the warranty of habitability and getting needed repairs from your landlord. So there's this phenomena in New York City landlord-tenant law, and it goes like this. The landlord says, "Hey, tenant, you owe me rent." And the tenant says, "No, I'm entitled to a rent abatement. I get a break on the rent because the warranty of habitability has been violated in my apartment. I need repairs that you, landlord, have not gotten done." And then the landlord says, "Oh, but those repairs would have been done a long time ago, but you, tenant, have not granted me, the landlord, access. No access." And the tenant says, "No, I was perfectly willing to grant you access." And the landlord says, "No, we tried repeatedly to get into your apartment and fix everything, but you blocked us from coming in." This is a dance that's done every day, many times in landlord-tenant court in New York City. Now, obviously, it's axiomatic that if a tenant does not allow a landlord into the apartment to make the repairs, that the repairs are not going to get done. So assuming the landlord is not just straight up lying about attempting to gain access to inspect and repair, then what might be some reasons that a tenant would hesitate from readily granting the landlord access? Well, I can think of 3 reasons that those of us working in this area frequently encounter for why a tenant will not allow a landlord access. But before we look at those 3 categories, there are people out there who just let the landlord in with the master key while the tenant is at work. These tenants usually don't have pets. They don't seem to care. They trust the fellow man. They trust the landlord and his vendors, and that's it. I'm not judging, and I'm not saying that this is the correct way to handle granting your landlord access to your apartment, but I'm also not saying that this is wrong. It's just what works for you. I guess I'm saying that for people who just let the landlord in while they're not home, you don't have to listen to the rest of this episode. So here are the 3 reasons that tenants deny access even when they need repairs. The first category of people who deny access even when they need repairs, I call them the logistical problem people. Tenant has a heavy job and works a lot of hours. They have childcare responsibilities, dropping the kid off, picking the kid up. There are many people for whom waiting around for the landlord's vendors to get there to the apartment to do work, that means losing a paid day of work or a vacation day. And this can be especially galling if the landlord's vendors show up at 1:45 in the afternoon and then leave right on the dot at 5 and then they want to return the next day. So those are your logistical problem people. The second category of people who deny access even when they need repairs are what I call the withdrawal of permission crowd. These are tenants who have allowed the landlord's crew in, and then because of the way the work progressed, it went too slowly, it wasn't going right, or maybe because of the particular people the landlord sent, they don't seem to know what they're doing, or they're rude to the tenant, whatever it is. Permission for access was given, but now it's been withdrawn. And now there's a conflict about access between the landlord and the tenant. Those are the withdrawal of permission people. And then the third category is what I call détente situations. Here, in a détente situation, the landlord never does all the work and the tenant never pays all the rent. Months turn into years, and the list of violations grows, and the rent arrears grow, and the tenant stops fighting for the repairs, and the landlord stops fighting for the rent. It's détente. And this is usually what we call a hairy building or a hairy apartment. Things just are not good there. And we'll talk more about this in the tenant takeaway. So today we're talking about when do you have to allow the landlord into your apartment to do repairs even when you do not want to, and how can you make these situations better? Okay, let's get into today's topic. Okay, here we go. So we're going to start with the New York City Housing Maintenance Code, section 272008. As usual, I'll put the links to all these rules and statutes I'm talking about in the show notes. Now I'm going to read just a little bit. I'm going to try to be very animated when I read. I'm sorry I have to read a little bit, but like I always say, people, the law is words. The law is words, and your landlord is reading the words, so that's why we are reading the words. Okay. Housing Maintenance Code 272008. Owner's right of access. No tenant shall refuse to permit the owner or his agent or employee to enter the tenant's dwelling unit, the apartment, to make repairs or improvements required by this code or other law, or to inspect such apartment or other space to determine compliance with this code or any other provision of law, if the right of entry is exercised at a reasonable time and in a reasonable manner. That's not a ton of guidance here in the Housing Maintenance Code, but there's the general principle. You have to let the landlord in for repairs. Okay, fine. So then next we're moving to a whole other section of the law. The rules of the Department of Housing Preservation and Development, and this is their regulation 25-101. Owner's right of access and requirements for notification. Okay, so this is really where we get to the meat of it. Okay, so this rule calls for the landlord to give the tenant a special notice before the landlord can come in. So I'm going to tell you 5 things about this, and this is really what you need. And it's actually what a lot of landlords don't do. I don't even think landlords know about this, so let's go through this. So the notice the landlord needs to give to the tenant in order for the landlord to have a right of access has to be in writing and dated. So we're not talking about a phone call. We're not talking about, well, I guess we could be talking about a text. But a text, well, I guess a text is dated. I don't know. I've always seen this more as a notice. So it's a notice and it has to be in writing and dated. It also requires 1 week's notice. So whenever they're sending it, they have to send it in such a way that even figuring for mail that you're getting a week's notice. The notice has to contain a statement of the nature of the improvements or repairs to be made. So it can't just say we're coming. It has to say what they're going to be working on. The notice also has to say that the hours of access are going to be somewhere between 9 and 5, and it can't be weekdays or holidays. That's when it's permitted. Between 9 and 5, can't be weekdays or holidays. Now, having said that, If they're in your apartment doing work at 5 o'clock and they have a half an hour more work to do and they're willing to stay till 5:30, I'm sure that's going to be fine with you. Finally, and this is goes more to what happens when they get there. Any representative of the owner needs to be able, upon demand by the tenant, to exhibit an authorization by the owner that authorizes access. The right way to do this is to tell the tenant in the written notice the name of the vendor that's coming to do the work. And when the vendor gets there, they should be able to exhibit those credentials to you. A lot of times, if you ask a vendor for that, they're just not going to have it because, again, so many landlords don't even know the law. The statute also talks about emergency situations. And while this episode isn't about that, I just want to put that in there quickly. There's no advance written notice required for an emergency. Then we have a little something extra for rent stabilized tenants that rent stabilized tenants should be aware of. It's Rent Stabilization Code section 2524.3E, and that says that the landlord can attempt to terminate your rent stabilized tenancy if the tenant has unreasonably refused the owner access to the apartment for the purposes of making necessary repairs or improvements required by law or authorized by the DHCR. Now, as a practical matter, I don't think I've ever seen a rent stabilized tenant evicted for not letting the landlord in to do repairs because the court would always intervene and strongly encourage the tenant to allow access and would order access at specific times, specific dates. So finally, of course, a lease can always make any requirement more stringent for the landlord. So you should always check your lease provision about access. I'm just going to read you a typical one. Now, this isn't a typical standard form lease. Will say something like, during reasonable hours and with reasonable notice, owner may enter the apartment for the following reasons: to erect, use, and maintain pipes and conduits in and through the walls and ceilings of the apartment, to inspect the apartment and make any necessary repairs or changes owner decides are necessary. Now, that provision, that standard provision, doesn't add to the week-long notice, but I could envision a lease that might. So just check that too if you're looking for what your rights are. By the way, of course, I'm linking to all these statutes in the show notes. I often get asked about two excuses for tenants not wanting to allow access. Sometimes the tenant will say, I just want to do the repairs myself and I'll bill the landlord by not paying the rent. That can work if the landlord is on board with that, and I would get that in writing, not formally, but email, text, something from the landlord before you start doing anything. Because if you don't have that agreement with your landlord, the tenant can't do her own repairs and bill the landlord. The authority for this basically comes from the lease, the contract between the landlord and the tenant. Most leases will say that the tenant can't build into, add to, change, or alter the apartment in any way. The landlord is supposed to do the repairs. Then sometimes tenants say to me, well, I needed to see the contractor's license, and the contractor wouldn't show me the license. And by the way, I don't like when they use ABC company. Last year they sent XYZ company, and they were much better. And now the landlord's being cheap, and I want to go back to XYZ. I like those guys. I don't like this company. The problem with that is I can't find any authority that gives the tenant a right to ask for a contractor's license before allowing them to enter the apartment. In fact, I actually found a DHCR proceeding which would only apply to rent stabilized tenants, but that says that the tenant is not allowed to challenge repairs on the basis of the contractor's unlicensed status. That's not a thing. So let's try to tie all this together in the tenant takeaway. It leads to some very important tenant takeaways here, but first let's get the housekeeping out of the way. This is not legal advice, and I am not your lawyer. But because I am a lawyer, this might be considered legal advertising. If it's legal advertising, it's just terrible because I'm asking you not to contact me. This pod is not a commercial for me or for my law firm. This is simply the podcast that I always wanted to make. Let us know what topics you would like to hear more about. Please subscribe. Give us your very highest rating and spread the word about this unique resource on your socials. Nobody's covering what I am in this amount of depth. Nobody's pulling together the Housing Maintenance Code, the rules and regulations of the Housing Preservation and Development Agency, the Rent Stabilization Code, your lease. Like nobody's pulling all the threads of each topic together to give you a nicely woven picture of what your rights really are. Because why? Because it's complicated. And that's what we're doing here. So please spread the word on your socials. And it's time for the tenant takeaway. Tenant takeaway time. Okay, I'm going to take this slightly out of order. For you logistics people, you people who are busy and childcare and work, what you can do is point the law out to your landlord, particularly the part that says they're supposed to give you in writing 7 days notice. You can say, look, I want to cooperate. I really do. The point is, the law gives me the right to the notice. And the whole point of giving me a week's lead time is so that I can move my busy schedule around to give you the access. Or that advance notice, the more you give me, if I tell you, hey, that's the day I have a very important meeting, or that's the day of my kid's school play, I can't let you in that day, then you have time to shuffle around your vendors. So let's just work together. I have a right to this particular kind of notice. You're not giving it. I'm not going to hold it against you, but we need to coordinate here because guess what? If I don't work my job, if I don't do what I have to do, then I can't pay the rent. So let's just work together here. Now, for you detente people, the people where they're not doing the repairs, you're not paying the rent, the years are going by. Again, there's no judgments here. I just have a comment. What I dislike about this is that it's not a long-term solution for either side. Eventually, those repairs are going to have to get done for a couple of reasons. The worse things get in your unit, the more it spreads to other units, like infestations or leaks. Bad things in your apartment don't stay contained. So even if you can tolerate them, the work needs to be done. And also, the landlord will eventually have to take steps in the court system to gain access because here's how that goes. The landlord might be refinancing or selling. And if they're refinancing, the bank might say, why are there 37 open HPD violations on apartment 43? You need to clear those up before we lend because no lender wants to go in deeper when there's a lot of repairs because that could mean the city could come in and the city could do the work and they'll do it for 4 times as much money. And then it becomes a lien against the building that competes with the loan. Or there might be a sale and who knows, maybe they buy the building with cash or somehow they get through the bank and the bank doesn't make them clean up the repairs. Whenever you have a new owner, whenever there's a new sheriff in town, they are not going to sit with 37 HPD violations against one unit. The new owner's always going to go through and attempt to clean that kind of thing up because the whole point of an acquisition is to maximize profit. So a new investor wants a violation-free building and a healthy rent roll. So one way or another, this isn't a long-term posture for a tenant to get used to. And the other thing is, it's not for nothing, you deserve a healthy apartment. So it's like pulling off a Band-Aid. You just got to start somewhere and let them get back in there and start working on the repairs. And look, if you had bad conditions for many years, you have documentation of that at HPD, and you should be entitled to a healthy rent abatement for the whole period of time that you didn't have a healthy apartment. It might not get you 100% abatement, but you will be entitled to something. Finally, for you access deniers who are frustrated by whatever the landlord is doing, either logistically, scheduling wise, or based on the quality of the work, for you, I fear you turning into a detente apartment if you don't let them in. So you have to let go of control over the actual work. You know, I want them to use XYZ and not ABC. I liked when they sent Ramon and now they're sending Vinny. Like whatever it is, you really can't control that. So you need to focus on what you can control. And what you can control is that the repairs have to be done. It's not so much important how the landlord does it, but that it gets done. And that's where you put your pressure. So on the website for the podcast, which again, I'll put a link in the show notes, we have that very comprehensive resource. It's completely free. I don't even think I asked for your email address. How to get repairs in your apartment. It goes through every step from the least aggressive step and how you ramp it up over time, and it's got everything in there. So your job is to concentrate on holding the landlord's feet to the fire to get your repairs done. How they do it, you should just let go of that, and it's one less thing for you to worry about and to have to stress over. It's the landlord's job who comes in and how they do it. But the end goal has to be that it gets done. And there you have it. So, you guys, it's been 2 years and 43 episodes. So, this is the last show of season 2 of the Tenant Law Podcast before we start season 3. We have been renewed for a season 3. Well, since I'm my own podcast network, I had some pull with the decision maker about renewal because the decision maker is me, and I renewed me. So I will see you in April 2025 in season 3 of the Tenant Law Podcast. Remember, New York City, the law belongs to you. The law belongs to you. But your ownership of the law is only as great as your understanding of the law. So let's learn to live better. I am Michelle Itkowitz, and this is the Tenant Law Podcast.